I'm Adam Friedman, and I'm joined today with Senior Appellate Counsel at Friedman Bartolo, Steve Vargas. Steve, how's it going?
Great, how are you? Thanks to be here.
Doing pretty good. So today we're going to be covering U.S. Bank N.A. v. Musnick. It's a Nassau County decision decided by Judge Marber, and the litigating Friedman Bartolo attorney was Partner Zach Gold. So Steve, before we jump in, you want to give us a brief capsule summary of the case?
Sure. It's a rare decision in which a trial or appellate court interpreted the CPLR 3408M extension of time to file an answer, which applies only in residential foreclosures involving a home loan in which a defendant is a resident of the property subject to foreclosure. And the residency issue is critical to the court's determination here.
All right, so before we jump into the specifics, I'll do a brief recap of the timing. So a complaint is initially filed by our office in February of 2023. The borrower, who's a non-resident of the property, is served in Long Beach at their residence, right? Again, not at the subject premises in Merrick. An answer is later filed 4 months later, about 4 months later in July 16th, okay? July 17th, there's a conference. On that same day, our firm rejects that answer as being not timely filed. And then fast forwarding again another 4 months, the borrower files a motion in November, a motion seeking to declare that answer as timely filed. Did I get that right?
Yes.
Okay, so you mentioned 3408, right? So can you just break down for the audience what 3408 does for a resident borrower's answer? What time period it gives them?
Sure. CPLR 3408A states that all foreclosure actions involving home loans in which a defendant is a resident of the property subject to foreclosure must have a CPLR 3408 settlement conference. 3408M is a subsection of the rule that allows a defendant resident who appeared at the first settlement conference a 30-day extension of time to answer. If a defendant does not appear at the first settlement conference, then or is not a resident of the property subject to foreclosure, then the typical time to answer begins to run from when service is completed, typically several months prior to when the conference is held.
Okay, and just to clarify, because anyone that's handled foreclosure settlement conferences knows they can go on for a long time. I've had cases that have gone for years, right? So that extension of time to answer only applies to the first conference, right?
Correct.
If you appear at 10 of them, it doesn't go from the 10th conference, it literally runs from the first
Correct.
conference. Okay. So now it seems like what you're saying here, though, is this extension of time is laid out clearly in the statute. Is that correct?
It is. It's explicit in the statutory
So why is
text.
this unique? Why is this, if it's laid out in the statute, right, why is this unique? Why is this important?
There are very few cases that actually interpret the statute. And that's where I think the unique aspect of the case comes in. That's why, in my opinion, the court reporting service elected to publish this decision. They noticed there are very few decisions addressing who is eligible for the extension of time to answer under CPLR 3408M. And in this case, the trial court, Judge Marber, made it clear a defendant must be a resident of the property subject to foreclosure to avail himself or herself of the statutory protection.
So where would you say this ranks in importance relative to the industry, right? On a scale of 1 to 10, how important is this decision to the default industry?
I think on a scale of 1 to 10, something like a 4 or a 5. The decision like this should really incentivize plaintiffs' attorneys to look very closely at who's appearing at the first settlement conference and whether that appearing defendant actually resides at the property subject to foreclosure. That can be done typically by looking at the affidavits of service, potentially some financial documents submitted at the first settlement conference. If the defendant is not a resident of the property subject to foreclosure, then the statutory extension of time to answer is not available. That answer should be rejected, as was done here. Otherwise, the plaintiff is inviting unnecessary litigation, delay, fees, costs, and risk that a defendant would somehow submit a potentially meritorious defense to impact the ability to complete the foreclosure.
Okay. Thanks a lot, Steve. Thanks for joining us. Congrats again to the litigating attorney, Zach Gold, on this decision. If you have any suggestions or requests for future cases you want Steve and I to cover, please shoot me a message or leave that in the comments. Thanks a lot.
Thank you.